Hi, my name is Michael Hayes, and I'm a member of the Board of Directors of CCE and a former member of the Executive Committee. And I've been a member, geez, I don't remember how long, probably since the 1990s. And the project I'd like to talk about for the History Project is the first project I did for CCE, which was the study of the grand jury system in federal court and in Superior Court in DC. And the final report was entitled The Grand Jury of Tomorrow. Um, the project was initiated by either Sam Harahan or me. I can't recall which one of us actually came up with the idea. I know I'd discussed with Sam over time the idea of engaging in a project, and this was one I think that appealed to both of us. And when we started the selection of people for the committee, Sam was insistent upon having former grand jurors to give us a perspective on the functioning from their standpoint. And I was initially a little suspicious of this since you're pulling people from random. But as it turned out, it was a terrific idea, and I think made the project much more meaningful. And they provided incredible insight into their experiences and how the system could be improved from their standpoint. We were incredibly fortunate to get federal district court judge at the time, John Garrett Penn, to be my co-chair. And he was a wonderful guy. He's since deceased, but was so kind and thoughtful and giving of his time. And the project could not have succeeded, I think, without his assistance. So we pulled together the committee, which was comprised of many of the prominent white collar practitioners in DC, and we had academics, I believe three current judges actually at the time, and it was just a wonderful experience. We had the meetings at the U.S. courthouse, thanks to Judge Penn, and we had spirited conversations about all of the topics from both the prosecution standpoint and the defense standpoint, and what information should be available. How could you protect the secrecy of the proceedings? I mean, there were just a ton of really exciting and interesting issues. And the one of the conversations I'll never forget was when we were discussing whether we needed to place certain limitations on what the prosecutor could do. And I'll never forget, Irv Nathan said that there was a lot of debate about whether or not we should include this, whether it was necessary. And Irv Nathan said that, this is not an exact quote, obviously, but it was something to the effect of the system shouldn't rely on the good faith of individuals, but there should be some protections involved. I've never forgotten that. But in any event, one of my more memorable moments from that was when Sam and I went to go see the then chief judge of the U.S. District Court to get permission to talk to some of the federal grand jurors to get their perspective. And the meeting did not go as smoothly as we had hoped. Towards the end of the meeting, Judge Penn was there as well. But at the end of the meeting, or towards the end of the meeting, she threatened to hold us in contempt if we talked to any of her grand jurors. So that ended that effort in terms of talking to federal grand jurors. But we did talk and had a number of Superior Court grand jurors. So I think the project was very important. I mean, it's been cited by the U.S. Court of Appeals in at least one decision, and when adopting one of our recommendations. And it was a terrific experience, and one of the most enjoyable and meaningful ones I've had. So that's my historic statement.